Genetic testing company 23andMe has filed for Chapter 11 bankruptcy protection, and that prompted a warning from California's Attorney General telling users to delete their data and have their genetic sample destroyed. You got to fingers crossed that happens, right? The company says it's trying to restructure in order to sell off its assets. The co-founder and CEO Anne Wojcicki stepping down from the company after a failed bid to take it private, and that is raising a lot of questions about what could happen to all that sensitive personal data the company has. The California Attorney General writing in a statement, due to the trove of sensitive consumer data 23andMe has amassed, Attorney General Bonta reminds Californians of their right to direct the deletion of their genetic data. Joining us now is Laura Coordes, law professor at Arizona State University and an expert on Chapter 11 proceedings. I feel like we've talked about Chapter 11 so many times, but this is very different. This is very sensitive. This is talking about stuff that comes out of us, that we give as samples. 23andMe says it wants to sell. So would user data be included in the sale? And how do they make sure of that promise that it will be deleted?
Absolutely. So yes, 23andMe is seeking to sell all of its assets in bankruptcy through this Chapter 11 process. And 23andMe's database of genetic information could very well be sold because that's an extremely valuable asset. By one count, it's over 15 million customers' genetic data. And so yes, that's an absolute possibility that it will be sold. Any buyer of the data will be required to comply with applicable privacy laws. But it is important for consumers to be aware of what privacy laws apply and what don't, because those laws aren't total safeguards. And then a buyer could ultimately choose to change the privacy policy once it acquires the assets. And customers would have to agree to the change. But again, people are going to have to be aware of what those changes are and make hopefully informed choices about what they're doing.
Yeah, let's take a look at what the company is saying. We've got a statement here, and it reads, the company intends to continue operating its business in the ordinary course throughout the sale process. There are no changes to the way the company stores, manages, or protects customer data. So what's your response on that? Because, many people are wondering if the bankruptcy process makes the user data more vulnerable. Is it protected in any way? What do we know about that?
So there are some bankruptcy protections for customer data. I mean, bankruptcy is a public process, that's right. But in a way, that's a good thing because that means that regulators like the Federal Trade Commission or state attorney generals can become involved in a case and can make objections to anything that the debtor is trying to do with the privacy, or excuse me, data. So there are some protections there. It's also possible for the bankruptcy court to appoint what's called a consumer privacy ombudsman. This person will, or could, if they're appointed, investigate any possible sale of assets and decide whether the company's treatment of those assets, of that data, is compliant with the company's privacy policy and any applicable privacy laws.
I'm curious what you think of the California AG's warning. Should customers delete their data, or should they hold tight? And to your point, that maybe, let this play out before anybody does something.
Yeah, so I think the key thing is for customers to be aware of their rights. If they are uncomfortable with what's happening, they do have the right to delete their account if they so choose, or they can revoke their permission for their genetic data to be used in research. It may be, as of this point, the fact that the company's in bankruptcy itself doesn't necessarily make the data more vulnerable. And there should be some protections for that data going forward in the bankruptcy process, and certainly protections in any sale of that data. So waiting and seeing is an option, but I think the more important thing is to just be informed of what 23andMe can do with your data now. As I understand, their privacy policy does permit them to transfer customers' personal information in the event of a bankruptcy sale. And so customers should be aware of that and then the possible implications.
Yeah, it's so crazy. I know so many people, I'm sure you do too, who have taken part in this, or people that were just shopping around, like which one are you going to do, Ancestry or 23andMe, or an open source one? 10 states have laws for direct-to-consumer genetic testing companies like 23andMe. Last question, do we need more guidelines on what should happen to user data when those companies go down? Because I think that most people that spit in a tube didn't see this coming.
Absolutely. I think more guidance is definitely called for here. As you mentioned, there are 10 states that have consumer privacy laws that cover genetic testing companies, but that's only 10. And there really aren't the same level of federal protections. This isn't covered by HIPAA. This isn't like talking to a doctor or a hospital. And so I think having more guidance here could be very, very helpful.
Thanks so much for watching. Just go to joinnn.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.